If you're a Texas parent going through a divorce or a child custody case, this is one update you do not want to miss. Starting September 1st, 2025, there's a brand new law, HB 2495, that's shaking things up in family courts across Texas. So what's this law all about? HB 2495 says that in every order appointing joint managing conservators, the court must now specify which parent has the exclusive right to enroll your child in school and decide which school they'll attend. No more guessing, no more loopholes, and hopefully a lot less fighting in court over where your kiddo is going to spend their days learning the alphabet or algebra. Let's break this down. In Texas, it's super common for parents to be named joint managing conservators. Basically, you share big parenting decisions. But here's the catch. If your court order doesn't spell out who gets to decide school stuff, things can get messy. Maybe one parent wants the best public school, the other's pushing for private, or you just live in totally different districts. I've seen parents end up right back in court because the order was silent on this one issue. HB 2495 fixes that. Now, judges have to make the call in every case, filed or pending after September 1st, 2025. And if you're asking to modify an old order after that date, the judge will address it then too. Let's make it real with an example. Jessica and Marcus are co-parents. She lives in League City, he's in Pasadena. Their daughter's in 3rd grade, and both parents want her at different schools. Before HB 2495, their custody order just said joint managing conservators and left the school choice wide open. They end up back in court and the judge has to figure it out anyway. But now, under the new law, the judge must assign that right to one parent, looking at what's best for the child. Things like stability, distance, school performance, and support services. So here's what Texas parents need to do. If your case is pending after September 1st, 2025, expect this to be part of your final order. If you're modifying an old order, it's definitely coming up. And if you already have a final decree, the law won't affect you unless you go back to court for something else. Want to be prepared? Talk to your attorney about how this law applies to your situation. Start gathering any evidence that shows why your choice of school is in your child's best interest. Think academic scores, commute times, special programs. And don't wait for a fight to start. Bring this up in mediation or hearings if you and your co-parent are in different districts. Here's my pro tip. Even if you and your co-parent are getting along great, circumstances change, addresses change, school zones change. Having this spelled out in your court order protects your child's stability and your rights as a parent. Bottom line, HB 2495 is a smart move for Texas families. It brings clarity to a question that affects your child's daily life and future opportunities. If you found this helpful and want to know more about Texas family law, check out www.thepalmerlawfirm.com. I'm Sean Palmer with the Palmer Law Firm, where we can't protect your heart, but we can protect your rights.